Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
My name is Matt Miller, and I'm a partner with K&L Gates. I focus on healthcare M&A. K&L Gates is one of the world's largest law firms with nearly 50 offices globally and a national healthcare practice that spans the East Coast and West Coast of the U.S. I'm your host today, and we're going to be looking at part 2 of Rep and Warranties Insurance, RWI, and how we use it in the healthcare industry. Andrew Lloyd is a partner in Charleston and New York at K&L Gates, and he focuses his practice on publicly and privately held entities, including private equity and venture capital firms, and does M&A, divestitures, and other negotiated transactions in a wide array of industries. And we are talking about rep and warranty insurance. This is a 2-part series of episodes. If you haven't listened to part 1, go back and listen to that. We talk a little bit about rep and warranty insurance at a basic level, and specifically in the healthcare context. In this episode, we're going to talk more about practical tips for structuring and negotiating rep and warranty insurance policies. We're going to cover some challenges and common pitfalls with rep and warranty insurance. And we're going to look to the future of rep and warranty insurance as it's used in M&A transactions generally. So hope that you are ready for another interesting round of discussion. Andrew, thanks again for being with us, and welcome back to Triage.
Thanks, Matt. Glad to be here.
Andrew, I got to ask you, what is your favorite part about living in Charleston?
Depends on the time of year. All right, in January, it's not that cold. In the summer, close to the water, so you can try to escape the heat and the humidity. But generally, it's nice to be. It's nice to be on the coast. There's a plethora of activities here, and it's a real vibrant culture.
Yeah, it's a pretty great place. I was just reciting Nashville, New York, Charleston. Those are all great cities, which is one of the great things about working at this firm. But anyway, let's get to the topic at hand, rep and warranty insurance and practical tips for structuring and negotiating rep and warranty insurance policies. So we talked a little bit at the last episode how different terms in the agreement can affect the coverage of policy, like the knowledge definition, for example. How would you go about from the perspective of the buyer in assessing your need for rep and warranty insurance and negotiating both the purchase agreement and the insurance policy?
So if I'm on the buy side, I think the first, one of the main initial drivers of the need for rep and warranty insurance is the particulars of the transaction. Am I being approached in this transaction as part of sort of an auction process with a investment bank working on the sell side to take this company to market? Because I think increasingly, certainly over the last decade, we've seen a huge increase right in the rep and warranty insurance market in the U.S. And I think sort of at this point, all of the investment bankers know about that, and they're going to push to get the best deal for their clients on the sell side. And a big part of that is an insistence that buyers bid with rep and warranty insurance in mind to offload exposure to the sell side, the bankers' clients essentially. And so, in the context.
So you're talking about just advertising the idea of insurance in the LOI, just.
Exactly. I think it's a bid enhancement. I think in this day and age, most auction processes for transactions of a size that would support rep and warranty insurance, the bid process letter is going to tell buyers that they're expected to bid with a structure that contemplates rep and warranty insurance, or at least approximates a deal that would have rep and warranty insurance, i.e., you can get it if you want. That's your choice, buyer. If you don't want to get it, you can't shift the risk back to the sell side. So I think in an auction process, again, in a competitive auction process, I think as a buyer, you've got to expect that other buyers are going to be bidding with rep and warranty insurance.
Yeah, and a lot of the auction drafts of the purchase agreements that you look at, they're often pretty seller friendly, as you might expect. How does that play into getting coverage, and is that necessarily a bad thing, or does the buyer want it to be a little bit more buyer friendly so it can enlarge the scope and get the more of a benefit of its insurance?
Great question. And again, I think, we're already sort of talking in the context of an auction process. And so let's sort of continue down that path with that assumption in mind. So I think, just generally from a deal perspective in that context, a buyer's got, maybe a decision to make, right? How badly do they want the transaction, right? Then I think this touches on rep and warranty insurance, but it's more of a bigger picture deal consideration, right? If they feel like this is an extremely competitive process, they need to not just be competitive on price, but other deal terms, in order to win and be selected and be able to purchase the asset in question. They may want to take a lighter touch to the reps in the purchase agreement, rather than marking them up very heavily and, creating even an insured transaction where the rep and warranty insurance back transaction where the sellers have comfort that, they're not going to have exposure for breaches of those broad, more onerous reps, buyer favorable reps. They're going to say this creates a disclosure burden on my part, right? I have to go through all of these marked up reps that I hadn't seen before. There's low dollar thresholds in here. There's all of this subject matter that's covered, and I've got to go disclose against all of these items. We're going to produce a bunch of contracts. So, I think just as a deal dynamic, how a buyer feels they need to position their bid is one consideration. But just generally, I think having an auction draft to react to, it's almost like, it's in a sense, it's like a almost a blank canvas for a buyer, right? They're going to be, right, a typical auction draft has limited in scope reps, both in terms of subject matter and then the depth at which they're addressed. If a buyer's confident they're going to win the transaction on price alone, or terms that really don't touch on how heavily they mark up the reps, then, they've got a lot of latitude to put in their preferred set of reps, working with their outside counsel and other advisors to send that back. Again, I think, where there's rep and warranty insurance in a transaction, a buyer side policy, typically that it's going to offset risk exposure to the sellers. And so, generally speaking, sellers should be inclined to live, as it were, with those reps, and the sort of heightened disclosure process that goes with it, because they're getting a better deal in the sense that there's not a, onerous indemnity contingency that's hanging out there over their heads, so to speak.
Right. So it's a bit of a give and take where it just depends on a variety of factors, right? Maybe leverage, maybe how attractive you want your offer to stand out in relation to the competing offers. It could also depend on the type of business you're looking at, right? Do you ever see anything other than just marking up the bid draft, or when it comes to, say, closing deliverables or even like post-closing integration issues related to rep and warranty insurance? Like what I'm thinking about is, particularly in the billing and coding side, if you see a certain payer mix, that can cause you to take one approach versus if you see a different, like mostly, say, federal payers and very few private payers, like that can cause you to take another approach. Do you tailor your approach not only just, in a bid or auction scenario, but just based on the company itself? And I think you mentioned last time the importance of getting in the deal team early to look at that diligence, and how do you approach that from a risk reduction standpoint when you're trying to make your offer stand out, yet you want to protect your buyer as much as possible?
Yeah, all good, all really good considerations. I think that, again, going back to getting, we mentioned it in part one, as a buyer, getting your internal team spooled up early, getting your outside advisors spooled up early, or at least as early as you can in the process, because, let's assume it's an auction, sellers hate last minute surprises, right? And being able to put your best foot forward with a bid, including saying, hey, we've looked at, potentially risk heightened areas like billing and coding and sort of, key regulatory requirements. Or, for example, if you're in the healthcare space, but you've got, say, the target's a company that provides patients with services where in a subsector where there's not, say, strict licensure requirements. Thinking of something like home health services, where, an insurer, a rep and warranty insurer, just given the nature of that business, they may have some, a little bit more concern around providing coverage. So going back to the auction context, if you have the time to get in front of your insurance broker as a buyer and have them take the transaction to market, again, on a confidential basis, right? Your broker is going to be signed up to a non-disclosure agreement or a joiner to the NDA that you've got in place with the target company. And then they're going to be able to take that and get sort of back-to-back joiners or similar non-disclosure obligations with potential insurers. Again, obviously, you got to make sure that the terms of the sell side NDA that the buyer has at the target would permit that. But again, I think, typically they're generally okay with that, right? As long as these folks like insurers are bound by the corresponding confidentiality obligations, because that's going to make bids more attractive. The more work you've done, the more certainty you can put around a bid and have the insurance market react before your bid goes in. And so you can get from the broker sort of a bid grid. Here's what we're looking at in terms of availability of coverage. Here are the insurers that are interested in providing coverage. Here, if there's any upfront deal exclusions that you can't sort of get worked out in advance, right? Based on, say you get some quotes come back. There's some exclusions that are a little surprising because it doesn't seem like that's the industry that the target operates in or relevant to the industry, subset of the industry the target operates in. Your broker can take that back to that particular carrier or carriers and explain that, and maybe you can get that exclusion lifted. Or if you see, hey, the market does have concerns about billing and coding risks at this target. So, we in order to provide coverage, we're going to require that there be a third-party audit conducted around that area. So the more information you have prior to the bid going in, the better your bid's going to look. And, again, I think that goes to, okay, if we can identify risks up front, identify and get comfort that there is going to be coverage available and that there are insurers willing to quote in the space, I think, that puts, it better positions a buyer. It avoids surprises down the road. I think particularly troubling, right? If you don't do that, you tender a bid, you're the selected party, and you get down the road and you find that there is no insurance available, or the insurance that's available isn't on terms that are attractive to you for whatever reason, exclusions, et cetera. Then that creates a pretty tough conversation with the sellers and their financial advisor. They thought this was going to be an insured deal. You still like it at the price, but you can't get insurance. And so how does that shake out? Well, that's some, uncomfortable conversations. We typically have folks put in when they put a bid in. I think unless you're in a situation outlined earlier where you feel like you need to win the deal, not just on price, but on other terms, and it's extremely competitive, right? We're willing to do this without insurance. You typically say we expect to get insurance to essentially offset or eliminate exposure to the sell side as applicable, assuming that, insurance is available on customary terms, and again, subject to there being no deal-specific exclusions. Try to give yourself a little bit of wiggle room in that LOI or bid letter if and when you need to point back to that as once you get through underwriting. If there are issues that you uncover in your sort of confirmatory diligence after the LOI stage, or you can't work away with the insurance carrier, based on specific concerns that they have as a result of the diligence that's been produced. And, having that language in the LOI helps because, I think it helps because you can point back to that when you have a conversation about the need for a specific indemnity and how to tailor that. You say, well, we didn't tell you we were going to give you a complete walk away. We did, subject to there being no deal specific exclusions. And there were these issues at the business that, you should have known about, maybe you knew about. Now you're telling us about it in diligence. And, this is fair game for a deal specific sort of indemnity in the purchase agreement.
So let's say we have a signed LOI, or we're in an auction process and we've won the bid and we've gone out to our brokers and we've looked at a couple different carriers. Can you talk briefly about the process of actually, going from that stage to actually getting policy issued and bound, and practically what does that look like, and what are the steps involved, and what input, if any, does the buyer, assuming it's the buy side policy, what input does the buyer have in that process?
So process wise, I think, again, I've mentioned sort of having your broker take the deal to market as an initial step, and they'll ask insurers for their appetite and, on what terms they would be willing to underwrite coverage subject to underwriting and diligence and the more specific terms of the policy. So you get a quote grid back, and that quote grid from your broker is going to be based on non-binding indications of interest or NBILs from the carriers. And so those letters come back. They have sort of the general economic terms, deal-specific concerns. They have heightened underwriting, sort of lay out the high-level terms of the policy. So from there, you typically have some back and forth with the broker. They may go take some feedback to particular insurers, trying to get them to quote better terms on premium costs or initial retention and the like, get them more buyer favorable. I think this is a good stage for folks on the buy side to talk with their brokers about, the particular carriers who are quoting and, what has been their experience with claims. How has not just claims, but underwriting. How have these folks typically handled the underwriting process with similar businesses? What's the claims experience been with that broker and, the various insurers that have provided quotes? Again, sort of giving you a better sort of total understanding of the mix of information to make a really informed decision about who to select as a underwriter insurer for the transaction. And once you've picked an insurer, they'll generally require sort of a non-refundable diligence fee that's credited against the policy premium, say $30,000 to $50,000, give or take. And that's sort of to cover the cost of their outside legal counsel. They'll get data room access and participate with them on the underwriting call. It's sort of the next step in the process. So once you've selected an insurer and you've got to line up the underwriting call, it's the next sort of main step in the process again.
What is the underwriting call involved? And talk about that a little bit.
To get to that call, as a sort of a precondition to having that conversation, that call, the insurer is going to want, and they're going to want their outside counsel to have copies of the, buyer's outside counsel's legal diligence memorandum, red flags memo that was prepared in connection with the transaction. They're also going to want to see sort of all of the other similar formal diligence reports from third-party advisors. So that's accounting, typically a quality of earnings report prepared by your buyers, outside accounting advisors, and alongside that, typically a tax diligence report performed by the buyer's outside tax advisors. If there's environmental concerns, was there an environmental consultant involved? Is there an environmental report? Again, say did a billing and coding audit. Is there a billing and coding audit that's available? All of those outside advisor reports are going to have to be handed over to the insurer and their outside counsel. Typically before they're willing to schedule an underwriting call, because they typically want at least a day, maybe 36 hours with those reports, so they can prepare for the underwriting call. As outside counsel, we provide our report on a non-reliance basis, and typically that's what outside accounting firms want as well. So insurance carriers won't be surprised to get a request from a buyer that they sign up to a non-reliance letter with various advisors, including outside legal counsel.
Got it. So let's just say, hypothetically, right? Say you're about to go into one of these underwriter calls. Say I have a friend that's about to go through an underwriting call. What practical tips would you give? And is it just kind of set the stage? Yeah. What does it look like? Who's there? Is it who from the company is there? What should they be thinking about? What should their counsel be doing in preparation for that call?
So the calls themselves are typically anywhere between an hour and a half, 2.5 hours. For a more complex business and a larger transaction, may be on the longer end of that or slightly beyond that. Sometimes they're pretty quick and we can get them done in, an hour, 15 minutes. It all sort of depends on the nature of the business and the transaction in question. But for these calls, on the insurer side, it'll be the insurer. They'll have their outside counsel on, typically, a corporate M&A specialist on for most, if not all, of the call. And then their various specialists will be hopping on and off the call as we get to their areas in the agenda. So you typically get an agenda from the insurer before the conversation happens. Sometimes it's detailed with specific questions. Sometimes it's more of just a, going topic by topic, setting the stage for a conversation where they're going to, ask questions coming out of their review of the various diligence reports and materials they've seen, and the purchase agreement and the disclosure schedules. Your broker will be on, and then on the buy side, outside counsel typically on for the entirety of the call. Again, similar to the insurer's side, you'll have M&A folks on for the entirety of the call, and the various specialists as outside counsel hopping on and off the calls. Their various topics are addressed. Similarly, the buyer would have their accounting advisors and tax advisors on, and then the other specialists that conducted diligence where there were reports sort of furnished to the insurer and their outside counsel as part of the process. That sometimes means that there are going to be folks, at the buyer that are on the call. Say, for example, tax diligence was conducted in-house, or, healthcare regulatory diligence was conducted in-house or partially in-house, and partially through outside counsel. The insurer is going to want to hear from the folks who conducted the diligence as part of getting comfortable in underwriting the various aspects of the target company. That said, these underwriting calls are, they're not depositions. And I don't think that, buyers should go into the conversation with, undue concern or anxiety. They're really just conversations. And, you typically, questions are asked, and then you got to provide truthful answers. But if you don't know the answer to something, it's perfectly fine to say, let us follow up with you on that. Because inevitably coming out of these calls, the insurer and their counsel are going to have follow-ups. Even if nobody says we'll follow up with you on the conversation, they're always going to have follow-ups. And so it's perfectly fine to say, let us look at our diligence and we'll get back to you on that. The insurer will follow up on that without fail, but that's generally much better than saying, I don't know. We don't know about that. We didn't look into it. Similarly, if somebody, if your answer is we didn't look into it, you need to be prepared to explain why. Simply saying, well, we didn't look at that aspect of the business because we weren't concerned. It really isn't sufficient. You have to say, well, we didn't look at that risk or this area because we didn't view it as material to the business for XYZ reasons. And you have to have those reasons and need to be able to articulate them to the insurer so that they get comfortable that, we're fine underwriting that risk because of XYZ reasons.
So let me ask you, so it's a trend a lot for representing the buy side when you're conducting diligence of the target, that you'll do kind of a red flag type due diligence process where there'll be some materiality thresholds established. So we're going to, if it's a below a certain amount of materiality, we're not going to really dig really deep into this because we're just going to be more efficient and sort of just look at the main things, right? So that probably is not looked at too favorably from an underwriter's perspective. Is that right? Or, that's probably not a good answer to tell them, well, Mr. Underwriter, we didn't look at that because we had a materiality threshold subjectively set by the buy side, right? Like they're looking for more, more cogent reasons and how does sort of this red flag review, how tolerant are insurers of that diligence process, or are they looking for something on average that's more detailed and more into the weeds than maybe a red flag review would suggest?
I think a lot of insurers, or most insurers perhaps, are comfortable with sort of what we call a red flag review. Inevitably there's various levels of what, people put it another way. A red flag review is kind of in the eye of the beholder, right? You've got to do some diligence, and some folks may characterize their diligence as a red flag review or just as the level of diligence that we conducted. I agree. You're not going to really get away with just not diligencing below. We didn't diligence below some level of materiality that we established that is just, way too high relative to the enterprise value of the target company. I think, for example, like on a lot of tax diligence reports, they will sort of set, they'll establish a level of materiality, which is a little easier to, handle on things like tax and accounting because it's quantifiable to a certain extent. I think insurance carriers are generally comfortable with that. I think if they don't they don't like the threshold that was set, they'll ask about it, or they'll tell you they're not comfortable with it, or ask you why you set it where you did. But, I think from a legal diligence perspective, I think carriers expect just as a default, they expect the entirety of the business to be diligence from a legal standpoint. Now, if you can articulate why a particular aspect isn't relevant from a materiality standard or threshold or consideration, they may be willing to entertain that. But I think it's sort of facts and circumstances based. On the flip side, some buyers, I think particularly sort of strategic buyers, relative to private equity buyers, I think, a lot of strategic buyers, for example, for integration reasons, right? They want to understand, at a more granular level, the nature of the contracts, the terms of the contracts that are being acquired, and the like. And so they, say even, in the absence of a rep mortgage insurance transaction, they might want a more fulsome, detailed diligence memo with appendices and exhibits summarizing, various groups of contracts, for example. I think insurers are perfectly fine getting that. They're always happy to get more diligence readouts, but I don't think that disadvantages a buyer. And I don't think that, buyers should say, we don't want that level of diligence done because it's an insured transaction. So I think you have to weigh things here, right? Where it's particularly important for integration purposes. If that's part of the diligence that a buyer wants conducted, I don't think that they necessarily should shy away from that. It's just, taking into account the total mix of what's going on in the transaction and the various aspects, including rep and warranty insurance.
So I want to kind of get to a couple other topics in our last few minutes here. But so the underwriter call is complete. Talk quickly about getting the policy bound and issued, and what that, when is that practically complete, and when does the coverage actually go into effect?
So, once you've had your underwriting call, generally once you've had your underwriting call, you'll, in addition to getting follow-ups, you'll get from the insurance carrier, through your broker, a draft of the insurance policy and the binder agreement. And so the policy itself is what determines coverage. The binder agreement sort of lays out a summary of the terms, but then also lays out the conditions precedent to, an obligation on the part of the insurer to issue the policy, right? Pay the full premium, close the transaction within, X days, X months of purchase agreement being signed, no material amendments to or waiver of conditions precedent in the purchase agreement and the like. Once you've got those draft documents, you'll work, outside counsel will work to negotiate the terms of the policy, try to push back and get more favorable terms where applicable and appropriate, and where there's latitude to do that. I think, again, that's something that's done together hand in hand with your broker, who also has particular expertise in looking at those policies, negotiating them, and have also got a very wide breadth of knowledge given their space in the industry, as a broker in these rep warranty insurance transactions. So negotiate the policy, negotiate the binder, deal with any, as part of that, deal with any deal-specific exclusions that are proposed. Can you get them narrowed? Can you get them removed? And at the time that the policy is essentially in final form and the binder agreement's in final form, you sign the binder agreement, insurer signs the binder agreement, and it is essentially, you're conditionally bound. Typically that's done most often at the time the purchase agreement is signed. So, on the day, concurrently with signing the purchase agreement, you would conditionally bind coverage under the insurance policy, which means that, you are essentially going to have coverage of the reps that you receive in the purchase agreement as they're made at signing. And so let's assume it's a simultaneous sign and close transaction. The reps are made on the signing date, which is also the closing date. Okay, sign the binder agreement, and then all you have to do is really satisfy the conditions precedent to issuance of the policy, and you'll be covered. So in a transaction where, say, for various reasons, if you've got if it's you have an HSR Act filing, you need to clear antitrust, you have other regulatory notifications, waiting periods, approvals that are necessary. So you sign the purchase agreement, again, go typically conditionally bind the purchase agreement at the time you sign. And then when you close the transaction, you would also provide, in addition to providing on the signing date, a claims or no claims declaration. Hey, I don't know about any claims. One of the conditions precedent to policy issuance is that you deliver on the closing date a no claims declaration, right? I don't know about any claims. I don't know about any rep breaches in the purchase agreement. And you satisfy the conditions precedent. Again, post closing, policy is issued, and you've got coverage typically for reps made on the signing date as well as reps made on the closing date.
Right. So that's for a bifurcated or a separate sign and close where you sign first, and then often is the case in healthcare transactions in particular, there's some sort of period, whether it's licensure or whether it's mandated, like you said, by HSR or some sort of regulatory statutory waiting period. And then you close, a certain period after. That's when you issue this no claims declaration and certify to the insurance carrier that, hey, nothing's changed. Everything's just like it was on signing. And then, like you said, that's when coverage is bound. So can you like walk us through, so let's assume we have a binding policy in place, and let's say there is a claim. I think it'd be just interesting to go through like a hypothetical in maybe just a couple minutes, just to pick something out of the hat. Let's say HIPAA. Let's say there's a HIPAA breach. And let's say that there's a rep in the purchase agreement that is on, germane to that. And let's just say that the policy, let's just say it's a $10 million coverage limit. Let's say the HIPAA breach is $4 million claim, right? I think you said before there was, 1% a retention. Can you walk us through how that would work in terms of, the buyer bringing a claim against the seller and then seeking recovery ultimately under the policy, and just the various retentions / deductibles that would apply, and then how that ultimately gets paid, just as a simple hypothetical.
Sure. So I think as an initial matter, claims typically tend to come pretty early in the post-closing period. Maybe 75% of the time, I think claims are noticed within, a year after closing. So, one of the things that buyers can do to help themselves put their best foot forward in terms of the claims process, where there is a claim out there, is to make sure that the right folks at the company being the buyer, are aware that there's insurance in place, are aware that there's contractual indemnification from the seller, where that's the case. And so that when things like, say, this hypothetical HIPAA breach come up, obviously we're dealing with that from a go forward business perspective, right? How do we triage this? What are we going to do in terms of how does this affect our business going forward? How do we deal with this? But there's always the backdrop of, well, maybe there's some coverage here that's available. So, I don't think you want to sit on these types of issues. The sooner that these issues can get identified and elevated to the deal team at the buyer, and then, can get elevated to outside counsel and the insurance broker who's there to help through the claims process, the better. Because, in a situation like you outlined, where there may be some contractual indemnification available from the sell side, but there's also subject to, say, a deductible in the purchase agreement, and obviously the retention in the insurance policy. So you've got the buyer, you've got a number of constituencies. You've got the buyer making the claim under the purchase agreement and also under the insurance policy. You've got the sellers who may be paying out through an indemnity escrow, and then, or maybe beyond that, subject to the terms of the purchase agreement's indemnity, and then you've got the insurer. So again, I think all very facts and circumstances specific based on what the purchase agreement terms of the indemnity say. Is it a precondition? For example, is it a precondition to making a recovery from the escrow in the purchase agreement, the indemnity escrow, that a claim first be made against the insurance policy? I think a lot of purchase agreements say that. A lot of sellers say, hey, you cannot come after me for any money, make a claim against me until you've tried to recover, or at least you've tendered a claim against the insurer under the rep mortgage insurance policy. So again, this all goes back to the sooner folks involved in the transaction, like the buyer's deal team, outside counsel, and the rep mortgage insurance broker can be made aware of potential issues, the better, because getting out in front of that I think goes a long ways in making the claims process more smooth.
Talk a little bit about, like, is there any obligation on the part of the buyer to mitigate the losses before it brings a claim?
I think there's generally a sort of a common law duty to mitigate losses, and so that's I think always out there. And typically in purchase agreements, in a negotiated indemnity in a purchase agreement, there'll be some standard of mitigation, whether that's simply contractually reciting the common, an obligation to comply with your common law duty to mitigate damages, or something that maybe is more onerous to a buyer in terms of mitigation. But again, in the insurance policies, those are going to contain an obligation that the buyer take steps to mitigate their damages. Failure to mitigate may not necessarily preclude recovery, but again, it's facts and circumstances specific. So to the extent that there was something that was, a reasonable mitigation action that wasn't taken, and, the insurer feels like that's created, a meaningful increase in the loss in question, they may raise that. Well, I think a lot of insurance policies, contain a requirement that if the insurer feels that the insured should take certain steps to mitigate the loss, that they should notify them, or if they feel that those particular steps aren't being taken, they should notify them. So there's some typical back and forth in negotiating the policy terms around mitigation and otherwise that, can have a meaningful impact, perhaps on the availability of recovery under the policy. But again, in these policies, it's typical that, you identify a claim, you're obligated to notify the insurer, give them information similar to making an indemnification claim under a purchase agreement. You have to describe the particulars of the claim to the extent you know them, identify the relevant reps in question, provide information, and that sort of kickstarts, or starts a bit of a back and forth. The insurer has to respond. Typically, they'll ask for more information. They may deny the claim outright, but they'll typically ask for more information. And again, having outside counsel, having your rep warranty insurance broker involved early in this claim process, I think generally it's going to make them go a lot smoother, because you've got folks who see these claims fairly frequently and are going to be well versed in sort of how to navigate that claims process. Frankly, I think denials, just flat out denials of rep warranty insurance claims against insurers under these policies are pretty rare, right? It's not that you never see them.
What do you do if you get a denial? If you're the buyer, if you're the policy holder, the insured, and you get denied for a claim you submitted under the policy, have you ever seen buyers appeal that, or is there a mechanism for doing that, or how does that work itself out typically? I guess it would be potentially a suit against the insurer for coverage, right?
That's right. And again, it's funny. The insurance policies contain a lot of the provisions that you'd see in an acquisition agreement that are relevant for disputes around. You've got a dispute adjudication of indemnification claims in a purchase agreement, and you've got similar provisions in insurance policies to handle that. Again, I think if you get a denial and you can't resolve that at a court, or as it were, you look to the policy terms and. Is that what was negotiated? What was negotiated with the carrier at the time the policy was put in place? What are the policy terms there? Right. Is there an obligation, say, first to conduct, non-binding mediation? Is that something you have to go through? Is there a litigation provision, or does it go through arbitration? And so, again, depending on what you're able to, or what you want to, negotiate with the carrier, that's going to dictate how you would resolve a dispute there. But again, I think that, it's pretty rare to end up in litigation or arbitration with an insurance carrier over a rep warranty insurance claim. Now, obviously, that's not to say it never happens, because it certainly does. And there's definitely cases out there addressing policy coverage terms. But by and large, I think folks have had real positive experience with claims treatment, claim payment from insurance carriers across the market, as it's become a really broad market with a lot of players here who really understand the specifics and the ins and outs of these, transaction documents and deal terms.
So 2 more questions before we wrap up. Can you speak a little bit to the post-closing integration between the parties and how might rep and warranty insurance help smooth that out or facilitate that in any way?
So I think as post, part of it is, right, as post-closing integration is undertaken, you've got a strategic buyer. That's a real opportunity to identify potential claims. So again, if this is a transaction where a seller's exposure has been greatly reduced or perhaps even eliminated in a sort of a zero seller indemnity transaction where there is no contractual indemnity, absent fraud, right? The buyer's looking, again, as I mentioned, purely to the insurance
explain
policy.
that. You mentioned that earlier, but explain the zero seller liability. Explain what that is and set that up a little bit.
Zero seller indemnity, public style transaction is essentially a deal where the sell side, there is no contractual indemnification provision in the purchase agreement. You say the reps made in the purchase agreement says, hey, the reps don't survive after closing. That's it, right? They're done. Can't make any claims against the sell side for a breach or a rep or an inaccuracy in a rep, absent fraud, right? There are certain, that's a whole different topic of discussion, fraud and its various permutations and what you can and can't disclaim liability for. Right. But, broadly speaking, right, generally speaking, no claims other than fraud. In that case, right, the buyer is looking purely to the rep warranty insurance policy for, recovery in the event of, an inaccuracy in one of the reps of the purchase agreement that's discovered after closing. Or that's discovered, say, after signing, but before closing, as an interim breach, right, that the insurance policy would cover because the reps were made at signing. And if the reps were made at signing and inaccurate because of something that existed at signing but wasn't identified until the interim period before closing, that's an interim breach where the policy should, again, sort of generally speaking, provide cover. If that's, the policy recourse is really the buyer's only avenue there, that's a zero seller indemnity transaction. So back to the integration question, I think as part of an integration process, that's just, you're more likely to, through that process, identify earlier on, or just as part of the process generally, issues that may present, themselves as, matters that were, constituted an inaccuracy in a rep or a breach of a rep. And having that insurance policy out there, why I mentioned earlier, where those issues are identified through integration or otherwise, getting out in front of them so that they don't sit for, months and months and nobody says anything about it. And then, 8 months out, we forgot about that. A few months ago, we identified this issue, might be a rep breach. And, does that timing issue, the failure to notice, create concern around availability of recovery? Were there actions that could have been taken in that interim period after it was discovered that weren't taken and now can't be taken? Did that exacerbate the relevant losses? In a transaction where you've got a private equity buyer and you say typically got some rollover from the sellers, and they're involved in the integration process, having that insurance policy, I think, again, makes it a little bit easier for the relationship, right? Because where issues are identified, right, and let's assume, right, there's no fraud, the sellers had no idea of these issues, that they existed. That eases any sort of, strain between the sponsor, the controlling owner, the PE firm, and the folks who rolled over in the transaction and maybe still involved in the operations of the business, right? Maybe these issues exist. It's not great, but there is insurance here. It's not like the buyer is going to recover, going to try to claw back purchase price proceeds from the sellers and potentially sort of create a real strain on that relationship that, folks really want to be hand in hand going forward as they look to continue to grow the business.
I have so many more questions I want to ask, and hopefully our listeners are really getting you have such a good grasp of these policies and how this process works. I know personally we've worked together in connection with rep and warranty insurance policies and negotiating coverage and M&A deals. in the last 2 minutes, I just kind of wanted to give you a chance to speak about what may be on the horizon, if you can. Maybe you don't have any ideas, but it seems to me that there's so many changes out there, whether it's in computer science, whether it's just in healthcare changing, whether it's just global issues, microeconomic, anything you really can speak to. How do you think that rep and warranty insurance is likely to change going forward, and how do you see it changing, and what are some trends that we should look out for in that regard?
Trends that we're seeing in the rep and warranty insurance market, and where does that look like it's going? Perhaps the main driver, a couple of the two big drivers in things from a macro standpoint, are how many insurers are there in the market, and that's really just gone up, right, since this product first really became more widely available here in the U.S. over the course of the last decade or so. I think that's really sort of when we started to see it, or at least I started to see it in the last decade, and it's just grown exponentially. And as that's grown, you've seen the growth of the number of insurers that are in the market and providing cover and underwriting these policies. So if as that market, I assume that market, it seems like it's going to continue to grow, because you've got a lot of seasoned deal practitioners, lawyers and non-lawyers alike, who are, partnering up with underwriters, and providing this product. So, the more players there are in the insurance market here, I think that's going to drive better deal terms on the whole for buyers. One of the things to think about is, as deal activity has generally slowed over the last year or a little bit longer than that, again, it's made it more competitive and more buyer favorable. If we see a real uptick in the number of deals, that probably perhaps, when we saw that in COVID and sort of the, COVID era, where there were fewer insurers in the market at the time, that created a real strain on the underwriting market. And what that meant was that, the smaller transactions, you had more difficulty getting, insurers to quote coverage, right? Because they were really looking at the large transactions to get insurance cover, to provide insurance coverage there. So as things move forward, I think those are two drivers to look at. And then just generally, look on the regulatory horizon. Are there issues that develop, creating concern for carriers in particular markets? And is that going to drive industry-specific shifts away from a particular area? Like, will there be more focus on healthcare? Are there going to be developments on the regulatory front in healthcare that scare insurers away from that market and towards another market? I think they have more latitude to do that when the M&A market broadly is really active, right? Because they sort of get their pick of transactions. So, all things to be on the lookout for as we sort of get into what may be a falling interest rate sort of economy here, and maybe a bigger uptick in transactions on the M&A space.
Well, Andrew, thank you so much for just your wisdom, your insight, just your breadth of knowledge and experience. Like I said, is really appreciated in this field. And I appreciate you taking the time. I hope everyone goes back and can listen to the first episode if they haven't already. This has been a great conversation. We talked about what is rep and warranty insurance, the role of M&A, rep and warranty insurance in M&A transactions. We looked at the healthcare industry. We've gotten pretty practical in this episode about how to structure rep and warranty insurance, some of the challenges. I think it's been really enjoyable for me personally, and hopefully our clients and listeners agree. Andrew, what's next for you? I guess summer's over, so anything big on the horizon?
Summer's over. My children are all back in school, which is great for my sanity. But that means, I think, we're hopefully going to see a real uptick in the transactions here in the M&A space. So it's now that I've got my kids in school for most of the day, it gives me a little bit more flexibility, or at least the ability to work from the home office without a bunch of unpaid interns screaming at me in the background.
Yeah, exactly. We'll get ready for the year-end push here. Thanks again. It's been enjoyable. So that's it for today, and we'll see you next time on Triage.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.